Good morning.
Good morning.
My name is Jonathan Rosenbaum. It's my privilege to appear on behalf of Constance Flint. My client, as you know, I don't mean to insult the court. To me, I don't really understand why I'm here, but hopefully the matter seems that obvious to you. But my client was a plaintiff in a divorce case. Her husband left her to take up with another lady named Paula Lambden. As the complaint alleged, Paula Lambden wasn't satisfied with just taking Mr. Flint. She, for some reason, embarked on a course of conduct to destroy my client, which I might add continues to this very day because she signs the Social Security check the check that balances out the Social Security in this case. So there isn't a month goes by that my client doesn't get her feelings hurt again. My client suffers from a disease called neurofibromatosis. Her appearance is not pretty, and she's very, very sensitive to this. And for whatever reason, Mrs. Lambden took it upon herself to not only destroy my client's marriage, but seems to want to persist in destroying my client's life. So we're not only here about the $1,700 that I got fined for daring to seek injunctive relief. We're here because I want my injunction, and I would like a remand to send this back to court so that Mrs. Lambden should have to answer for her conduct. I was fined $1,700 for what was allegedly frivolous conduct, to quote the court. Civil Rule 75 does not permit plaintiff to join Ms. Lambden as a party in a divorce. Pursuant to Civil Rule 12b-6, plaintiff failed to state a claim against Ms. Lambden. They ruled that my conduct was frivolous because there was no legal authority existed to attempt to join Ms. Lambden. Well, with all due respect to the trial court, Civil Rule 75, for a reason, I assume, only exempts the joinder rules of 14, 19, 19.1, and 24. It does not exempt joinder under Civil Rule 20. I respectfully submit that both the Supreme Court of Ohio and the legislature, when it affirmed these rules, knew what they were doing when they left permissive joinder in a divorce action. And permissive joinder a person can be joined permissively in an action as a defendant if asserted against them, jointly or severally or any alternative, any right to relief in respect of arising out of the same set of same transaction occurrence or series of transactions or occurrences. Well, I believe, honestly, that when one takes up with an adulteress and the adulteress persists in joining in conduct which destroys the marriage, that is a claim for relief when you seek an injunction to prevent that arising out of the same set of acts or occurrences. I don't see how it could be otherwise. And my client, through me, amended her complaint to specifically include some of the cruelties that she was enjoying. A divorce court in Lorain County has a greater jurisdiction than a general division court pursuant to 2351A2A2. In fact, it has all the powers of a general division court, plus it has the ability to hear domestic relations matters and juvenile matters. So I applied to the court for injunctive relief. I obtained an injunction that's standardly granted ex parte, prohibiting anyone to harass a party themselves or through another. I really think that this is clear under the law that anybody can do this. I understand, I guess, that a lot of people haven't, and certainly the trial judge had never seen this before, but with all due respect, I don't think that makes me wrong. I can read, and the rule says that permissive joinder is applicable. But it goes one step beyond that. Not only do I think that there was warranted under existing law the ability to do this, I think that it certainly cannot be deemed frivolous when I take this rule literally, and a literal reading of the rule permits me to do what I did. But despite that fact, the judge determined it was frivolous, refused to acknowledge that the rules say otherwise. I briefed this, I pointed this out to the court, it's in the record, and yet when I refused to dismiss my claim against Ms. Lambden, it was deemed to be frivolous after the case was over, and I was fined $1,700. So I'm respectfully asking this court to rule A, that not only was that conduct not frivolous, but it was permitted under the rule, and that Ms. Lambden has a right, or I'm sorry, Ms. Flint has a right to be heard back in court about an injunction against Ms. Lambden preventing what seems to be going on at least once every month. Thank you.
If I may.
Sure.
I guess you're pretty much going under Rule 20.
Yes.
75 you stays out, so 20 is the one you're looking at. You're saying that because your right to relief in respect to arising out of the same transaction, well, the divorce is a contract, it's a breach of contract type case, right? And you're alleging that Ms. Lambert, basically, there's a tort, you're saying, is that she's committed these torts against you. She's offensive, she's whatever. Because really, if you're going on the grounds being adultery, then that's the reason for the breach. So why don't you go get a CPO against her?
Well, I don't think that I don't think that this arises to the level of a CPO. I don't think there's any threat of physical harm here. My client was never in any physical danger. I think that would have been an abuse, and I think CPOs are all routinely granted. And even if that were an alternative remedy, I don't believe that means I can't pursue what I think the legislature clearly and the Supreme Court enabled me to pursue. I think the proper remedy would have been an injunction, which I initially had for a while.
Okay, under Rule 20, what I'm looking at specifically is language that says, any right to relief in respect to or arising out of the same transaction, occurrence, or succession or series of transactions or occurrences.
Correct.
Okay, so, and there's a conjunction, and if any question of law, but tell me specifically what right to relief arising out of the same transaction, occurrence, or succession or series of transactions or occurrences does Ms. Lambden have in relation to Mr. Flint?
Mrs. Flint has in relation to...
But in the marriage in general, it's a divorce case.
I believe that she's entitled to injunctive relief based upon harassment. That the courts commonly issue these orders in domestic relations matters. In fact, it was going to grant them ex parte. And I said in my brief, and I believe Ms. Lambden was lucky I didn't bring a separate cause of action for some sort of tort. But all my client wanted, and we didn't want to make a bigger deal out of this than it had to be. She wanted to be left alone in her own home. I mean, this woman was entering her home, sitting down, refusing to leave, and insulting her.
No, that's a trespass.
Right, and I could have sued her for it too. And it arose out of the same transaction. I don't think you can separate one from the other.
The transaction is a divorce.
The transaction includes, in this divorce, I mean, there are facts other than that pertain to a divorce, other than the fact that people are simply married or have a marriage license. And there's a whole set of surrounding facts that deal with the breakup of families, households, property, and everything. And part of this was, Mr. Flint chose to bring Miss Lambden, for whatever reason, into her house, into the former marital home, and harassed my client. And I think that, one, I think I'm proper under the law, but two, I don't think that it's certainly a good faith argument to extend that law or to explore this. It's certainly not frivolous conduct. I mean, obviously the legislature envisioned, and the Supreme Court, when it promulgated this rule, that there would be some other permissive joinder for these facts that would exist.
Let me ask you a question. When you file for divorce and you get the mutual restraining order that prohibits the parties from annoying, harassing, or asking anybody else to annoy, harass. So why wouldn't you file contempt against the husband for letting this go on? Why isn't he controlling Miss Lambden? Isn't there other avenues that you could have pursued?
Well, I personally do not believe it would be proper to take it out on Mr. Flint because he can't control Miss Lambden. There are other facts that aren't in the record here that led to that decision. And I'll say to the court is, trust me, this is not Miss Lambden's first experience in destroying a family. And someday I believe Mr. Lambden is going to wake up. But if you're asking me if I think locking up Mr. Flint would in any way deter Miss Lambden, I have to respectfully say no.
So what you're saying is that he is not instructing her, the record doesn't reflect that he's instructing her, if she's doing this on his, at his instigation.
The record doesn't really reflect anything other than the allegations that I put in my complaint, because I was not given the opportunity, which we would have welcomed, to prove what was happening here.
Right,
I was
but you're-
chucked out before I could even get to that point.
Okay, but you're not alleging that this was done at his behest, or?
I would say that he had to at least tolerate it. Whether he had the ability to stop it, I doubt it, but, I mean, he brought it to the home.
Okay. All right, no further questions? Do you have anything more for us?
No, thank you.
All right, then the court will take the matter under advisement and issue a written opinion that will be sent to you and the other side, and also you can look on our website. Thank you so much for your kind attention. The court is adjourned until next week.